We have everybody on mute. So as questions arise throughout the webinar, please type your question into the chat feature. You will see on the lower left-hand side a bubble, and it indicates that you can send a message to the presenter. And we'll try and address all of your questions, and if we aren't able to do so, we'll either aggregate the questions depending upon the volume that we have not answered and send out a response to all, or answer them individually. We will be hosting another webinar with similar content and more updated feedback. If there are others in your organization that you think will benefit from listening to it live, and I know there are some law firms who are also on the webinar. If you'd like some of your partners to listen in, we will be having another webinar at the same time in a few weeks. So look out for that invitation if you're interested in passing along that to your colleagues. After the webinar, we'll be sending an email with some resources and action items. So we'll send you links to view the SBA addendum, links to view the SBA's SOP, links to update your franchise registry account, and a summary of the issues that have been identified by franchisors thus far related to both the SOP changes and to the specific addendum. Now, some of you may or may not know this, but Ferndata is very active in promoting franchise lending. So in addition to webinars that we host twice a month for lenders, we present in person once a month to lenders at various conferences throughout the country. And we've been known to present with our Arby's hat on Wendy's wigs and the like. So in keeping with our promotion of franchise lending, I'm in full franchise uniform today wearing a Wendy's wig. And if you have a brand hat or uniform, please send it in to us. We could wear it at the next lender presentation. So today we're going to cover the SBA's SOP changes and how it will affect you. To summarize, the SBA's SOP changes has made it easier for SBA, harder for lenders, and therefore puts more burden on you to make sure that lenders have the right information. As with any change comes uncertainty, and there's a lot of uncertainty with lenders with these changes, beginning with, will you, as franchisor, sign the addendum? Under what conditions will you sign it? Will you sign it for all of your franchisees, for some of them, and when will you sign it? So the Franchise Registry will address all of these uncertainties for you. So I'm going to show you how the Franchise Registry will make the process as simple as the SBA intended it to be, how the Franchise Registry eliminates uncertainty and mitigates risk to lenders, and it will therefore open up the lending markets to your franchisees. So over the next hour, we will address what's changed, lender reaction, franchisor reaction to the SBA changes, the Franchise Registry solutions, and what you need to do today. SBA released a new standard operating procedure, also known as the SOP, on December 2nd, which became effective January 1st of 2017. These changes were largely focused on franchise lending, and they affect both the rules and the process around the very unique hurdles that the franchise relationship brings to the SBA lender. SBA is talking for years about changes. However, since there wasn't much time given for franchisors in the lending community to react to these changes, it's clear that the timing of these changes were designed to be put into effect before the next administration takes office. So last week, we hosted a webinar with SBA lenders on the SOP changes. This webinar was sold out with over 400 lenders. We have another webinar next week with an additional 500 lenders registered. During this webinar, we took a pulse of how lenders are feeling about these new SOP changes, and the results were overwhelming. 69% of lenders feel uncertain or negative about the changes. 78% are uncertain or negative about how these changes will affect the number of franchise loans that they will be able to make. Change always creates uncertainty, but these changes clearly created more uncertainty than the SBA intended. What I'd like to do is take a pulse of you folks on the audience to understand how you are, whether or not you've actually reviewed the SBA's new standard operating procedure. We're going to wait a moment to let those results come in. It's still tabulating. You should be able to see these live as they're changing. Okay. So I'm sure we'll continue to get more responses because we've got a lot of folks on the call. But right now it appears as though there are more folks on the call that have not reviewed the SBA's SOP, new SOP. Thank you, everybody, for participating. This is very helpful feedback. Okay. So about 50-50, a little bit, a greater number of franchisors that haven't reviewed the SOP. Now, how many of you have reviewed the new one-size-fits-all addendum? Results are pouring in. So it looks like more of you have reviewed the addendum than have reviewed the SOP. Okay, great. Thank you so much. Before we get into the specific changes, I think it's helpful to provide some historical context. For those of you that remember the SBA franchise reviews prior to the financial crisis, SBA only looked at a handful of issues that were focused on what SBA calls franchise affiliation issues. These are issues in the franchise agreement that SBA determined prevented a franchisee's ability to have the right to profit or sustain a loss commensurate with their own efforts. At the time, most addendums focused on the transfer issue almost exclusively. Then came the financial crisis, when SBA experienced unprecedented losses in their portfolio. SBA reviewed all of the defaulted loans and noticed a significant number of issues that lenders missed in their loan evaluation. Therefore, it was at this time that SBA started expanding their reviews. More rules came into the franchise affiliation review. SBA started reviewing other documents for other SBA requirements, and they started consistently making determinations on business eligibility. The most famous of these was Sola Salons and Salons by JC, which I'm sure most of you are unfamiliar with. They were taken off the Franchise Registry in August of 2009 because SBA determined that these businesses were passive businesses and therefore not eligible for SBA financing. This had nothing to do with franchise affiliation issues. It was business eligibility issues. In 2010, master franchise agreements were also determined to be ineligible for SBA financing. Also, not a franchise affiliation issue, but an SBA other requirements issue, and a business eligibility issue, And in 2011 is when they expanded all of their reviews to include all other documents. In some ways, as you'll see in just a moment, the new SOP is going back to pre-recession days. So over the last 7 years, SBA has put out an SOP nearly every single year. Since you don't live your lives in SBA SOP land, I think it's helpful to know that the SOP 5010-5H was put into effect May 1st, 2015. So that's the SOP that lenders have been living off for the past year and a half or almost 2 years. And the SOP 5010-5I, which is the current version, which was put into effect in January 1st, 2017. So the easiest way to illustrate the difference between SBA's new SOP and the old one is to have a side-by-side comparison. So in 2016, SBA, through the Franchise Registry, provided lenders with determinations on everything related to the hurdles that a franchise uniquely brought to the franchising equation. So let's review what was included at the time. So SBA provided determinations on whether a business brand was a franchise according to SBA's broad, unique definition. SBA provided determinations on business eligibility. SBA provided customized franchise affiliation addendums negotiated with Franchise System and a certification by franchise. And SBA negotiated streamlined solutions for other documents to meet SBA requirements. In 2017, SBA has provided a one-size-fits-all franchise affiliation addendum, which on the one hand means you won't have to wait for SBA to provide their determination. It's a sign it or don't get financing ultimatum versus a negotiation with franchisors relative to the language to meet their franchise system requirements. So this means there is a streamlined solution for franchise affiliation. In the process, there have been 3 risks that have been shifted back to the lender. The first is that SBA has changed their definition of a franchise. The lender must now determine whether a brand's business meets the FTC guidelines. The second risk is that the lender must determine business eligibility. For some insight into this, this is an area where franchises were held up for the longest period of time when SBA referred Franchise Registry applications to the Office of Litigation. When they were referred to the Office of Litigation, this is when the business operations manuals were being reviewed. In one case, a franchisor had to change the curriculum that it offered to its franchisees to become an eligible business. And third, the risk that has been shifted to lenders is that the lender must identify the issues and negotiate solutions with franchisors to bring agreements into compliance with other SBA requirements. So this includes reviewing other documents that they've never done before. And in the words of one lender who said this very succinctly on the webinar last week, or 2 weeks ago, excuse me, as a community banker, it will be impossible for them to finance franchises if these issues aren't already solved for them on a centralized list. So since the SOP was released on December 2nd, we are really only a month in to having digested these changes. Most of you haven't looked at the SOP, and a little more than half of you have reviewed the addendum. So, we're just coming out of the holiday season and year-end, where most of you have been focused on other things, and so a lot of you have certainly not tuned in until now. So in addition to this webinar, we've been educating franchisors and requesting feedback. And the feedback that we've requested and continue to request is that you tell us, whether franchisors tell us whether they will sign the addendum without question. If franchisors have issues with the addendum, and what issues you have relative to the entire SOP changes. So in addition to franchisors, we've also talked to loan brokers, franchise sales brokers, consultants, attorneys, all of your advisors. And the response thus far from franchisors directly is that 60% are positive that they will sign the addendum, and 40% have come back with issues. Those issues we have categorized, and for people who want to be active, have their voices actively heard, we're not only sharing the issues with the IFA, but also connecting individuals with the IFA to make sure that their voices and concerns are heard directly to the SBA. Now, for those of you that haven't seen the addendum, we will include the addendum in the email after the webinar, in addition to that summary feedback that I mentioned from franchisors thus far. But there are 4 topics in the new addendum, and in those 4 topics, they would equate to 7 of the previous rules. So this is a reduction in the total number of rules that SBA used to have in place in the previous SOP. The topics that are addressed in the new addendum are change of ownership, forced sale of assets, covenants, and employment. So the initial franchise community reaction falls into three categories: concerns, positive feedback, and unresolved questions. Franchisors have expressed concerns about the addendum specifically, and the concerns are really varied based on the franchise system, and some don't have any concerns. But I'll give you an example of a few concerns that have come up. For one, even though the SBA rules have prevented franchise systems from being eligible for SBA financing if they hire and fire employees, there has never been a customized addendum observed that includes language stating that the franchisor doesn't control their franchisees' employees. Many franchisors have expressed outrage that the addendum has embedded a presumptive link of joint employment. The franchise agreement explicitly states that the franchisee is an independent contractor, and that should be sufficient. Franchisors also don't know how they should address their step-in rights relative to SBA's restrictions on controlling employees. Additionally, the one-size-fits-all addendum does not provide franchisors with the ability to clarify the franchise agreement's intent or provide flexibility to explain more details around the process by which these provisions will be executed. For instance, franchisors lose the ability in advance to set some parameters within the addendum regarding what conditions they, as the franchisor, may place on giving required consent to, and some conditions regarding obligations after a transfer or termination. We've had a lot of franchisors explain that they don't care about the addendum. What they care about is that they have spent a lot of money creating solutions to streamline the issues that have come up in their other documents to now have to negotiate with each lender. There's also language in the previous SBA addendum that was designed to address lending and security concerns of the bank for many franchisors, including language to protect the bank's collateral and its priority interests. So franchisors will need to have an agreement with lenders, a separate agreement, to include some of these provisions. And franchisors are already considering that this separate agreement will allow them the opportunity to incorporate explanatory language that a franchisor may need. Franchisors that previously received financing because SBA was able to customize an addendum so that franchisees would not be calculated in the size assessment of a franchisor will no longer be able to obtain SBA financing, because they are summing the businesses, the franchisee businesses, with the franchisor in the size calculation. This has been identified as another concern. And there are franchisors who are unsure whether they will now be caught up in business model issues because individual lenders will have to be deciding on their own. Franchisors have also provided positive feedback. So the addendum has significantly reduced the number of rules that a franchise is subjected to relative to franchise affiliation. There's one franchisor in particular who had a loan that was supposed to close in December, and they wouldn't agree to provide options to their franchisees for billings and collections. And since that issue is not included in the new addendum, they just waited until the first of this year, and actually the second, because the first wasn't a business day. And so the franchisee was able to get financing, or the loan is now being processed with the new addendum. And franchisors have also provided positive feedback that they don't have to have a review time for franchise affiliation, and that's great for folks who don't have an issue with the addendum. There are some unresolved questions. The first that has come up is that since SBA has adopted the definition of a franchise based on the FTC rules, does that mean that the FTC exemptions apply? They talk specifically about one exemption, gas stations, which is included. So they have explicitly said that it is not exempt, but they haven't referenced the other exemptions. based on the addendum, it appears that previously ineligible brands, such as 7-Eleven, which is the classic example used by SBA, they appear to now be eligible. And it's uncertain whether that was SBA's intent. And finally, franchisors are wondering if this rule will be substantially modified or eliminated like the overtime rule was temporarily blocked by a federal judge. In fact, I believe that was the first comment that we received on the webinar today when we logged in. So for those of you who have reviewed the addendum, which was a little more than 50% of you, what is your reaction to the one-size-fits-all? Do you have concerns? Do you not have any concerns? Or are you still uncertain whether or not you have concerns? All right, the results are coming in and split evenly. Wow. Okay. So of those that have decided, it looks like it's 50-50 on have no concerns and have concerns. And there's a greater number of you who aren't sure yet. Okay, sorry for those of you whose results didn't get pulled. We're moving on to the next question so you can get your answers in. Do you know if other SBA requirements could affect your franchise system? And for attorneys, feel free to respond on behalf of your client system. Okay. A lot of uncertainty around other SBA requirements. It's a very broad topic without a lot of specificity on what that means, right? Okay, great. So, so most of you don't have any idea whether or not it will actually affect your system. So a question that has come up predominantly by lenders is, will the franchise registry operated by FranData be going away? This, of course, is very confusing because the SBA has never owned the franchise registry. So, of course, it's not going away. As a franchise system, you bring hurdles to the lending process that are very unique and that, unfortunately, provide uncertainty and risk to lenders. So the franchise registry has always solved these hurdles with you and erased this uncertainty and risk to lenders in a streamlined and cost-effective way, and it will continue to do so. And even though the SBA no longer makes using the franchise registry a requirement by lenders, lenders rely heavily on the information on the franchise registry. Since the SOP changes were put into effect, which has been a total of 2 days, there have been a total of 204 logins by lenders. To give you some perspective, there are 8,000 lenders on the site, and on average there are 15 new lender members a week for the past 2 years. So we've had some lenders who were concerned that the information that they rely on will go away, so they frantically started downloading all the documents off the franchise registry. Once we figured this out, we assured them that everything will continue to be in place so they don't need to waste their time. But it is confusing. And so we will continue to make sure that all of these historical documents, which are not available anyplace else, are available to lenders. And I'll show you why that's important. So let's get into start peeling away the changes and helping you, how the franchise registry is helping you through these changes. And the best way for me to show you is to how the franchise registry removes the unique hurdles in the franchise relationship is to see the lender's view of the franchise registry. So if we start with the main account page, every franchisor has a main account page. and it provides the business description of the franchise, the FRUNS number, which is the unique number associated with the brand, the NAICS code, or in some cases the many NAICS code that a brand operates in, the franchising status of the brand, if a company is a franchise or not, and the contact information provided by the franchisor, which tells the lender who they should contact and for which specific purpose. So the SBA contact is the person who signs the SBA documentation. The franchise financing contact is the person that addresses credit issues. The franchise salesperson is the person who deals with the referral relationships with the lenders. The contact information is really critical to ensure the ease of communication, and it will also be used for the e-signature delivery capabilities that will be available over the next month. Every franchisor on the Franchise Registry has a total of 5 folders of information to help lenders through the lending process. Today, we're just going to focus our time on where the folder, the SBA folder, and how it reduces the uncertainty for lenders. The first uncertainty and risk that a lender needs to be addressed is the question, is the business a franchise according to the FTC definition? Now, for most of us on the call, this seems simple and easy, but just remember, like many of you may not have known what an SOP was before this call, lenders did not know that the FTC had a definition of a franchise that was different than SBA's definition. So before, SBA's definition of a franchise was much broader and was only a 2-part test, use of a trademark and had a product or service. Therefore, it included dealers, memberships, distributors, etc., that are not considered franchises according to the FTC definition. Lenders don't really know the nuance of these 2 definitions, and this has always been taken care of for them. The good news is since we've always categorized business models based on whether they fit the definition of a franchise according to FTC. Yesterday, we flipped the switch for all brands that have a Franchise Registry membership, and lenders know whether your brand or your client's brand meets the FTC definition. For those that aren't franchises according to FTC's definition, but used to be considered franchises according to SBA's definition, there's explanatory language that describes why they aren't. This is important for those brands because they don't have to sign the franchise affiliation document, but they are subjected to the rest of the issues that we'll cover today. And it eliminates that back and forth of, no, we're not a franchise, yes, you are, back. And so saving time and money for both parties. The second uncertainty that you must address for lenders is, will you agree to sign the standard addendum? We've already received responses from over 150 franchisors who have agreed to sign the addendum, some grudgingly, some happily. Many franchisors are still digesting the addendum, as we saw from the poll earlier. And the affiliation section on the Franchise Registry will further tell lenders whether you will sign the addendum, whether you will sign it with certain conditions met, and when in the process you will sign the addendum. So as you've probably all experienced before, there's really a natural tension in this process. Lenders want the addendum signed the moment they meet their potential borrower. But you don't want to sign it unless you're certain that the franchisee is in fact, or the individual is in fact a franchisee with the signed agreement, or that if they're an existing franchisee that they're in good standing. So every franchise system is a little bit different in terms of their process, but the particulars of when you will sign, you will outline on the Franchise Registry. And we also know that not all franchises are that particular. So for those that aren't, and they will sign whenever, then we'll articulate that as well. SBA has made decisions on brands regarding business eligibility. We talked about this earlier on the historical timeline. This is a considerable risk to lenders, as loans without an affidavit for Curves for Women franchises were denied their guarantee. So what does this mean exactly? Loans that lenders made with the assumption that their 75 to 80% guarantee was in place, meaning that the government would pay them if it defaulted, were in fact not guaranteed. So if there is additional documentation required to meet the business eligibility guidelines, then this section will not only say whether the business is eligible, but if there's additional documentation for the brand that the franchisee has to sign, it will also be included here. So for instance, franchise brands that market their business to one segment of the population are viewed by SBA as potentially discriminatory. Therefore, they must assure the SBA and lenders that they are not discriminating against other segments of the population. Finally, there are risks relative to other SBA requirements. There are brands that have comfort letters, subordination agreements, lease agreements, and the like that have been deemed not eligible to meet the SBA requirements. Many of these other requirements are focused on credit issues that, for instance, impair the ability of the lender to foreclose. The franchise affiliation addendum, for instance, does not address one, large franchisor's lease agreements, which they will not modify for SBA financing for the purchase of real estate unless the franchisee has 5 or more locations. So for all of you with Franchise Registry memberships, any of your other documents that have issues that were fixed in your previous SBA addendums will be addressed in separate document and posted in the other SBA requirements section. And it will explain to lenders what was modified to meet SBA requirements. So all of the documents will refer back to previous decisions that were made by SBA at some point in time so that lenders have the documentation and the assurances that their guarantee is secure. So if there's one thing that I've learned over the course of these past fabulous 18 years is that lenders' number one concern is that SBA guarantee. So they would not be making the loan without it, and they want to be 100% certain that the guarantee is not going to be impaired. So the SBA consistently advises lenders that the paper trail of evidence is the way to assure their guarantee, and that's what the Franchise Registry will provide them. So how will lenders know that your account is updated to address the uncertainty and risk that the SOP creates? There are 3 ways. The first way is when a lender has a prospective borrower associated with your brand, they'll log into the Franchise Registry with their username and password. They'll search for your brand name and go into the SBA folder and see that your account is updated. The second way is that over 1,000 lenders have franchise brands in their portfolio. So lenders establish a list of brands whose franchisees they have lent to, regularly lend to, or want to lend to. We have lenders that have as many as 1,000 brands in their portfolio. That's extreme. The average is about 50 brands. And for every brand in their portfolio, the lender is alerted whenever there is a change on the franchisor's account. Any change to the information displaying on this page that you see on the screen will trigger an email. So what does that mean? Any information, brand name, Inc. name, changes in total franchise units, changes in existence of a fund report, adding a new bank credit report, a new franchise disclosure document, and finally, and most importantly for this call, changes in the SBA documentation folder. This includes updates to any piece of information in the folder, including whether you will sign the SBA addendum, when in the process you will sign it, if your franchise meets the business of is an eligible business, whether it meets the definition of an FTC, and if there are other documents to resolve other SBA requirements. In addition, lenders can customize the notifications based on brands within their portfolio and for the site overall. So lenders will be notified of any new franchise that has been added to the site for the first time, or any franchise that has agreed to sign the addendum for the first time. So for instance, if Phillips Seafood, which is a Washington, D.C. landmark restaurant chain who just started franchising, decides that they are able to sign the addendum, lenders would be notified even though this brand isn't in their portfolio. This is important to lenders both when they have a deal, if the account is being concurrently updated, and for business development purposes. To give you a sense of scale, the Franchise Registry adds on average 1 to 2 new franchise brands a day with new friends numbers. In addition, lenders are able to search for franchise brands who have agreed to the addendum and whose business model is eligible for SBA financing. And lenders also can further customize the search by putting in other criteria such as minimum number of franchise units or minimum number of years franchising. Every franchisor that has been verified on the Franchise Registry as being a franchise or not being a franchise has a friends number. So you may or may not know that, but your brand has a friends number. This system, friends numbering system, was adopted by the SBA after there was an investigation by the SBA's Office of Inspector General, pointing out that the SBA data that it was distributing to lenders was wrong. Not only was the coding system wrong by having duplicate codes for the same brand, in some cases we saw 6 to 7 codes, but the performance data was misrepresenting the actual performance in the SBA portfolio, and it was underreported by over 25%. The report that was issued by the Office of Inspector General was not a thorough vetting, but a cursory vetting of the data. And when FranData has cleaned up data, the underreporting has been significantly over 25%. Now, the friends number is important to the lenders as they use it to track their portfolio of loans to a franchise system's franchisees. So brand name changes and name changes are accurately reflected, but they stay connected to the same friends number. So for instance, an early childhood education franchise out of New Jersey changed their brand name from Rainbow Academy to Lightbridge Academy. It's the same franchise, but it's a different brand name. And brand name changes happen, as you know, for many reasons, including but not limited to trademark issues, expansion of product offerings, market research results, and other marketing reasons. And the friends is the backbone of our FranData's database and is the only way that lenders can organize and understand franchise brands accurately. So as I mentioned before, since I've been in this industry, I learned that the most important part of SBA financing is certainty around the guarantee. So we asked lenders, given the new requirements, where are you most concerned about your guarantee? And it is actually, I was very surprised that only 4% are not concerned about their guarantee given the new requirements. So the majority of lenders are concerned about their guarantee related to every part of the SOP changes. So what can you do to help reduce the risks and uncertainties that lenders have? I think it's important to first understand that lenders, they vary in size and sophistication. And it's important because your franchisees will be dealing with all types of lenders. So you have to know how to make it easy for all lenders to finance your franchisees. Some lenders have an assembly line production shop, so each person that is responsible in the process has their very small piece of what needs to be done for an SBA loan. Some lenders have one person who's responsible for nearly everything, and some lenders outsource all of their back office functions to a lender service provider. So in knowing that, what you can do today to make sure that lenders of all sizes understand that whether or not you are able to receive SBA financing and what issues are resolved is to update your account on the Franchise Registry. So you want the 8,000 lender members to know whether you will sign the addendum, under what conditions you will sign it, that your business model is eligible, and that other SBA requirements are addressed. This is something that you can do today to make sure that any lender who is talking to your franchisees has access to that information immediately. Also, make sure that your contact information is up to date to streamline document signing and to streamline any lender questions that come up in the process. And when do you actually renew your account on the Franchise Registry? So you want to renew your 2017 registry membership once your new FDD is ready. So you don't want to wait until it is approved in all registration states, because a franchisee in one state could be looking to get SBA financing while you're waiting for the other state to approve your registration. So Frandata will work with you at that time to update your entire account to verify and provide documentation necessary for each of the 4 franchise financing hurdles when your new FDD comes out. What you can also do now is understand how lenders are viewing your brand. So your Franchise Registry membership includes access to your franchise credit rating and report. This is really important for you to see and to understand and enhance, because lenders are making credit decisions based on your brand's creditworthiness. If you have not accessed it for 2016, please email us and we'll set up a consultation call to review it with you. Your Franchise Registry membership also gives you the ability to review SBA loans that are associated with your brand. And if the data is accurate, you can upload it to your other documents section in the underwriting part of the Franchise Registry to display to lenders. In the instance whereby this data is inaccurate, where it has happened for many franchisors that the data is grossly unreported, Frandata can search for missing loans so that an accurate representation can be displayed. You're also able to upload other documents to help lenders understand your brand. You should also see what lenders see and know what lenders are thinking. Currently, you have the ability to see certain activity that the lender does on your account. This includes when they access the SBA folder. In addition, you can view the lender's profile, what states they lend into, what percentage of their portfolio is to franchise lending, to give you an understanding of their level of sophistication and who they could be working with in terms of your franchisees or prospective franchisees. You're able to communicate directly with the specific lenders that view the information on your account by hitting the contact link. And over the next few months, we will show you even more lender activity so that you know more about what's important to the lenders based on who they are and the profile of that lender. Right now, lenders can search for you based on your profile. It really isn't fair that you can't search for lenders based on their profile. So therefore, we will be opening up the ability for you to search for lenders based on criteria such as, have lenders lent to your industry, what's their average loan size, their geographic footprint, whether or not they're a preferred lender. So this slide shows you a few of the search criteria that will be available to you. So we have 2 polls before we finish up, so I appreciate all the participation. How do you feel about SBA's SOP franchise changes? Now, I asked this question before, and I'm asking it now after you've learned a little bit more about what those changes mean. Okay. There's some uncertainty around the changes, and some are feeling pretty positive. I'm sure you're all wondering what I actually look like with a Wendy's wig, so here you go. You get to see that. I'd like to open it up for questions. So please, if you haven't had a chance to ask a question in the chat box, please go ahead and do so. And we'll try and get to as many as possible. Okay, let's take the first question. Actually, the first question is one of the most frequently asked questions. Is there any reason to believe that these will be reversed after January 20th? So as I said, this is we get asked this question by nearly every franchisor that we talk to. So I say that it's in order for any change, it's really important that we know your concerns. So my ask of you is for those of you, after you have a chance to review both the SOP and the addendum, is to email us or call us with your concerns. We're categorizing all the concerns, and we're also sharing them with the IFA. The IFA has had a few conversations with SBA that have included franchisors, and they've also talked to them by themselves to voice some of these known concerns. I will say that most of the issues that have been raised with SBA were unknown. So please do email us with your concerns. We will add them to the list, and if you want to be actively involved, we will connect you directly with the IFA. Okay, the next question is, we often get asked by lenders to defer royalty payments if the franchisee is in default on their SBA loan. Does this new SOP eliminate this requirement? So this is a good question. SBA has a section in the SOP called the Special Provisions for Franchises. This section is still in the SOP. However, it is not a requirement, and it actually never has been. So it basically says that lenders should consider obtaining agreement from franchisors that either allow the lender and SBA to access the franchisor's books and are able to not pay royalties or defer royalties or franchise fees until the borrower brings the loan current. So those provisions are not requirements. However, smaller franchisors may not have as much power if the lender makes it a requirement. Some franchisors actually provided the provisions that they were comfortable with agreeing to in their franchise affiliation document. And going forward, we would recommend having this as part of the other SBA documents, requirement documents, so you set clearly expectations with all lenders what you are and are not willing to agree to related to these SBA special provisions. Okay, so to confirm, do we have the ability to make verbiage clarifications to the new SBA addendum? Or do we have to make an addendum to the addendum if we want to customize it? So this is a good question. The SBA has made it clear that the addendum is a one-size-fits-all. You may not change this addendum whatsoever. What I was suggesting is that franchisors have told us that because they will have another addendum to address other lender requirements and other lender issues, that they may actually include explanatory language in this other document. So for those registry franchisors that have a previously approved SBA addendum, would it be a good practice to use it instead of or in addition to the new Form SBA addendum? This is a good question too. So I would not recommend using the previously approved SBA addendum. You must use the new addendum. However, the old addendum is accessible to lenders so that they can refer back to other decisions. So when we outline any other SBA requirements, will refer back to a previous decision, and the lender will be able to access that on the registry. So the value of the historical review still is very high because it provides that certainty to the lender around these other issues, whether it's the business eligibility, the other requirements. So it's good to have those documents available, and they will be available on the Franchise Registry. Okay. So one person asked, lenders are not required to check the registry. So what's the benefit of paying for data? It takes time, and the costs keep rising. So that's a good question. So the costs are fixed, and they do not raise. So I'll tell you what the costs are, and I'll tell you what the benefit. So the benefit is that, first of all, there's really not a time lag. I'd say that for new franchise brands who will need to have their new documents submitted, it will probably take about 2 weeks to process, just to make sure that all the other requirements are addressed. But for franchisors that have been on the registry, it will be a very simple timeline, taking less than a week. The cost that includes all of the things that we discussed today, both the management of the SBA documentation section, communications with lenders, and access to all the information, underwriting information that lenders are using. For emerging brands, which means brands that have 50 units or less, or have been franchising less than 5 years, it's not a hard and fixed rule, but it's a general rule. And so a brand that's been franchising for 30 years but has 30 units, they would not be considered emerging. So there is a little bit of wiggle room around those rules. But the cost is fixed at $500, and for brands that are mature and that have 50 units or more, 5 or more years franchising, the cost is $1,000. There's more lender management and more documentation and more credit risk associated with those brands. So the fees are fixed and the timeline is short. Okay, I have another question. Are there other ways to advertise my brand to lenders? Okay, so at this point, the best way to advertise your brand is to keep your account updated with full information to make it easy for lenders to find you, and so that you come up on these searches. You can also email lenders directly that have looked at your account. And coming soon, we'll give you the ability to tag lenders to send them updates on your brand, even if they don't have you in their portfolio. So that way you can advertise your brand directly to lenders. Next question. My attorney has handled my account in the past. Should they continue? So it's very, very important to have your attorney involved because all of these requirements are in your legal agreement. So you want to have their legal opinion on how to solve these issues. Additionally, if you work with a loan broker who helps your franchisees place loans, such as Benetrends or FranFund or DCV, they can actively manage your accounts to communicate with lenders and to work to establish relationships with lenders that are interested in your brand. Okay. Another question. The standard addendum includes a provision under covenants restricting the franchisor from recording against the real estate. We have a non-compete in our license agreement attached to real property so that an ex-franchisee cannot rent to a competing business for 2 years after the termination. We did not record this restriction. Is this new covenant provision meant to counter non-compete real estate provisions such as ours? So I think that's a very good question and not something that has been discussed. I would put that under the issues that SBA has not likely talked through. So I will put that on one of the issues that needs to be addressed in the next conversations with SBA. Okay, can you explain what happens if our business is not classified as a franchise under the FTC definition for one reason or another, even though it was previously considered a franchise for SBA purposes? Yeah, so what would happen is your account on the Franchise Registry would reflect that you are not a franchise and explain why you're not a franchise according to the FTC definition. So the affiliation document does not need to be signed. The other issues, business model eligibility issues and other SBA requirements, still need to be satisfied and dealt with. So the only thing that gets taken out of the equation is, one, it communicates to lenders that you're not a franchise, so you don't need to sign the affiliation document, and so making it easier for you. Okay, what do the lending markets look like right now for franchises? So we're hearing from a number of sources that lenders are tightening their credit box. So there were a number of lenders that expanded pretty rapidly in franchising over the past few years, and they've started to experience some losses and are starting to tighten their credit. And at the same time, though, there are a growing number of lenders that have plans to expand their portfolios with a select number of creditworthy brands. And lenders are using the various tools on the Franchise Registry to figure out which brands to work with. Do we still use a certificate? Excellent question. So no, there will be only the documents that you will need to sign are the affiliation document and any other and another SBA requirements document. A certificate does not need to be signed. Okay, let's see. Are there any questions? Okay, this new addendum will override any previous SBA addendums regardless of when the franchise agreement was executed. That is exactly right. So this addendum is now applicable to any franchisee regardless of when they sign the franchise agreement. Another question, are we supposed to be using the new addendum now when they are sent by lenders, or will this be in effect once our 2017 has been filed? Another great question. So you will sign the new addendum now, and with your 2017 FDD, you will file that to make sure that you communicate or that any other issues that are required to be resolved are also re-verified with your 2017 document. Okay, well, our time is up today, unfortunately. I really appreciate all the great participation. We've had a tremendous number of questions, and there are some questions that haven't been answered, and so we'll make sure to get those question answers. Thank you, and have a wonderful day, and please contact us with any other further questions.